Court does call the case of the people versus Valerie Johnson.
Joseph Development People, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, can you state your name for the record?
Valerie Johnson.
Your Honor, I have an application pending to schedule a meeting with Ms. Johnson, so I'd ask for an adjournment for that purpose.
Without objection, how much time? You have the application.
The application is pending, but I already have, I guess, my video visits approved. So once it shouldn't be very long, I can expect. That makes sense.
Okay. I believe that. All right. Probable cause conference will be here on September 4th.
Thank you.
2025, 9 a.m. Bond will continue. Thank you, Ms. Johnson.
Thank you.
Senator Greg here.
Really? No, go ahead. I'll wait. You got everybody? Court does call the case of the people versus Michelle Lovaz.
John Shea, Your Honor, with and on behalf of Ms. Lovaz, who's approaching.
Morning. What's your name?
State your name for the record.
Michelle Lovaz.
Thank you. All right. What are we doing?
Your Honor, the defense has been awaiting supplemental medical records for quite some time. Medical records take a long time to obtain. My understanding is the prosecutor's office has them. They will be tendering them to us. We will be tendering them to others who need to review them. I'm going to be out of the country between August 31st and September 19th, so we're requesting a PCC until after that.
Since September 19th.
Yes, sir.
You come back. I can do September 25th or October 2nd.
Your Honor, September the 25th will work just fine. At the 22nd, excuse me 1 second, Your Honor. Your Honor, it's September 25th for the time being. We may have a conflict with that, but if we do, we'll contact the court. I know I have a conflict on the 2nd.
Hearing no objection, probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you very much. Thank you, Your Honor.
Court calls case people versus Samuel Clauski.
And then on behalf of the people, Your Honor.
I realize, Ms. Cannon, you are trying to stand in my eyesight, so I know that you're actually here and we're waiting on somebody else. No, never mind. You don't have to say anything. I'm just saying, I get why you're there.
Filling in for Ed Drugas, the defendant. My apologies, Judge.
Your name, sir?
What's your name?
Samuel Clauski.
Thank you.
Your Honor, we are asking that this matter be set for a preliminary exam.
All discovery complete?
To my knowledge, yes.
People have their witnesses available the 2nd.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. Thanks, Your Honor.
All right.
Bond continued. Court calls case people versus Eric Lightheart.
Joseph Development People.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client who approaches.
Your name, sir?
Eric Lightheart.
Thank you. You're seeking an adjournment?
Yes, Your Honor. I'll have that go on.
That objection, probable cause conference will be adjourned to September 2nd, or September 4th, excuse me.
Your Honor, if possible, I was respectfully requesting consideration for the 18th of September. I fully expect the matter to find a resolution. I do not see this matter being set for an exam.
5 weeks out.
But I wouldn't be seeking any additional adjournments.
Any objection from the people?
No, Your Honor.
September 18th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you.
Court calls case people versus Kyle Beckerman.
Good morning, please, Honorable Court, David Burgess, on behalf of Mr. Fleckman. We got our discovery is complete. We're requesting exam on this matter.
Your name, sir?
Kyle Becker, Mayor.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue. Court calls the case of the people versus Tanya Marie. Oh, I'm sorry. Yeah, Tanya Marie Lee. Let's see, get that wrong. Nia Lee. They have it. They have those.
Andrew Childers appearing on behalf of the people. Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Lee. Ms. Lee, could you please state your name?
Nia Lee.
Your Honor, we're asking for an adjournment. There's some discovery that still needs to be produced, and we're working on a resolution. So a lengthier adjournment would be appreciated, Your Honor. Respectfully requested.
The 4th.
Like a 30-ish.
Pardon?
You said to the 4th, Your Honor? Could be a little
If
bit
I'm giving suggestions. Go ahead.
like the 18th, Your Honor, please.
18th. Why? This is 5 weeks out. The other one was a retail fraud. I don't even understand why we sent that out 5 weeks. And this is
Yeah, I guess that is a little bit lengthy. September
is.
11th, Your Honor.
September 11th, 2025, 9 a.m. Bond continue.
Okay.
Court calls the case of the people versus Christopher Decker.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Decker, who approaches. Please state your name.
Christopher Decker.
All right, you're requesting a forensic exam.
Yes, Your Honor. I met with Mr. Decker. There were some concerns raised during our meeting Saturday, so we're requesting a forensic exam. I've received the paper discovery from the people. The prosecutor also has provided me the email address, and I already sent over a request while waiting to be called for the digital discovery. I think the only holdup is how long it'd take to get the forensic center to see my client.
Forensic examination evaluation is ordered. I'll set a competency here, give me 90. We'll move it up. Yes, sir. November 13th, 2025, 9 a.m.
And Your Honor, my understanding is, I don't believe bond's been addressed in this, and we just asked the court to reserve that. There's a revoked bond from a case that's already been bound over to circuit court. So I don't believe any of this time is counting on this case, but we just didn't want the court to deny bond or take any further action until we get a response back
He's got a 25,000 cash. Sure.
on this case. Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Carlton Cross.
Yes, sir.
Mr. Feaster's case. Sir, can you state your name, please?
Yes, sir. Carlton Dion Cross.
Thank you.
Really, Judge, Portia Feaster, Assistant Public Defender.
Thank you for joining us.
Apologies.
What are we doing on this?
Thank you, Judge. I've been trying to work with the prosecutor to receive an offer on this case. I believe it's the first PCC. We have not yet received that offer. I will request a brief adjournment to see if there is an offer that we can possibly get to resolve this.
That objection, August 28, 2025.
Thank you, Judge.
Bond continue. Thank you, Mr. Cross.
And sir, Judge
I'll come
Simpson.
down and talk to you, Mr. Cross.
Okay, and Judge Simpson, and I've already, on my other case, I've already been released to treatment, and I'm just waiting for Miss Sarah at correctional service to come down and talk to me.
Okay, I'm sure that'll happen. Okay, and if there isn't an order on this case, they can prepare an order and I'll sign off so that this case doesn't hold you up, okay?
All right, thank you so much, sir.
Thank you.
Have a good day.
You do the same. Court calls the case, People versus Delorean, Hall. So.
Joseph Ignobit, people, Your Honor.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
Delorean, Duro.
Apologize. Your Honor, two things. First, I had spoken with Mr. Duro about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bond will continue.
Judge, I was hoping to address bond for Mr. Duro. Your Honor, Mr. Duro suggests that he has a number of community supports and stability in the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response.
Bond is set as appropriate to see
I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond as set is appropriate given the nature of the charges that I'm facing. But only after this criminal history. But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate as set. People prefer the court to make further determination.
At this point, what I'm going to do is I'm going to deny the motion to modify the bond in this case. The bond will continue. However, Mr. Bernstein, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court calls case People versus Alexander Sanchez Garcia.
Good morning, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present to my right. Mr. Sanchez Garcia, can you state your full name for the record?
Alexander Sanchez Garcia.
Thank you. You're requesting an adjournment.
I am, Your Honor, and I spoke with the people before stepping up to the lectern here. If the court would like more information, because the green sheet is a bit vague, then I'm happy to give it, but the people and I, we're asking for 3 to 4 weeks, Your Honor.
That objection, probable cause will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Bound continue.
Thank you, Your Honor.
Court does call the cases of the People versus Todd Reeberg.
Andrew Childress, people.
Carl Burdell appearing on behalf of Mr. Reeberg in the case ending in 5649.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Reeberg in all his other matters. Mr. Reeberg, could you state your name for the court?
Todd Reeberg.
Thank you.
And Your Honor, I would ask you to approach on these matters.
Come on.
Thank you.
Judge.
All right, record should reflect we had a bench conference in this case. You're seeking an adjournment.
Yes, Your Honor.
Yes, Judge. Because he's still awaiting potential release to treatment.
Yes, Your Honor.
What, the 4th or the 11th, Ms. Young?
Yeah, either works for me, Judge.
Either, Your Honor.
Did I ask Burdell? Didn't I say Ms. Young?
Oh.
Burdell thought I cared. No.
Probably the 11th, Your Honor.
Yes.
Thank you.
She's still doing great.
I am.
Probable cause in this matter will be adjourned to September 11th, 2025, 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor. Keep your head up, Todd. Thank you.
Court does call the case of the People versus Nolan Hearn.
Good morning, Your Honor. James Fifelsky appearing with and on behalf of Mr. Hearns. Can you state your name, please, sir?
Nolan. Oh, he just says.
Yeah. Your Honor, I'm asking for a brief 1-week adjournment for the video discovery, which I believe is forthcoming, and set this for PCC out at the next available date.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor. August 20th.
Okay. The court calls the cases of the People versus DaVon Langford.
And then on behalf of the people, Your Honor.
Sherilyn Foster Tucker on behalf of DaVon Langford.
DaVon Langford.
Thank you.
Your Honor, I am just jumping in on this case. I'm just requesting a brief adjournment to get discovery and review it with my client.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Tesa Michael, Tesa Mariam.
Joseph McGovern, people, Your Honor.
Good morning again, Your Honor. James Fifelsky appearing on behalf of Mr. Tess Mariam, who is approaching. Come on up, sir. Please state your judge.
I'm sorry.
My name is Tesa.
Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
It's not true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did.
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When did he say he went over there? Because I'll call right now.
Yesterday.
Yesterday afternoon?
Yeah.
They wouldn't have. It's not true.
I did.
I can tell because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Are they ready? Court does call the case People versus Carlos Sell.
Albert hearing on Mr. Self, who's approaching the podium as we speak. Carl, once you get up here, introduce yourself to his honor.
Carlos Sell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Does that explain the cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender, let me sub on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released, so we just have to extract it and watch it.
Give you my next available date, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, Saab.
Miss Saab, thank you very much.
Not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Joseph, people, Your Honor?
Mr. Denua?
Hi, be next door.
Really? Didn't do me any good.
Hello. I've been. How are you?
Oh, do you know what you're doing on your case today? Did you adjourn or you said?
What's he saying? He might adjourn video.
Video, okay. Very good.
Sorry, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Bastable. Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue. Court does call the case, People versus Tanya Hall.
Good morning, Your Honor. Robert J. on behalf of Ms. Hall. Tanya,
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
I believe we have a plea worked out. We need to do the paperwork. We're asking if we could set this matter to the 28th.
All right. I will adjourn this matter out August 28th, 2025, 9 a.m. Bond continued. Okay, Ms. Hall, we'll see.
Yes, sir.
You got it back on the 28th.
Yeah.
That's you. Okay.
Court does call the case people versus Brian Gerard.
Assistant Public Defender, let me stop on behalf of Mr. Gerard. Your Honor, we are asking to set this for preliminary exam, and to my knowledge, discovery is complete.
Sir, your name?
Brian Gerard.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Ronald Lucky.
Josephine Gilman, people, Your Honor.
Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Kidwell.
Yes, Your Honor.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that.
Judge Otis
Well,
ordered it in
who
writing.
ordered it?
The one that let me out on bond, I believe Judge Otis, they wrote it down on a post, you know.
It's a Otatella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
I'm sorry.
Funny.
Right.
Right.
Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowell, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'll have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court.
Wait a minute, hold on.
That address.
Okay, we're gonna take care of it.
September 2nd.
Yeah.
September 2nd.
Court calls case. People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gabachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
That's fine.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour. Bonds will continue.
Your Honor.
Court calls case People versus Ashley Nader.
People, Your Honor. That's Mr.
Yeah.
Morning, Your Honor. Rob J. Kill on behalf of. Judge, in this matter, we're asking.
Your name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Kilowog?
Judge, I'm not sure where I am this morning.
Okay. Wait, that leads to confidence for your clients. Come on.
He wants you to go take ETG, see if you got any alcohol in your system.
All right, in essence, you're seeking an adjournment of these.
No, we're saying preliminary exam.
Exam. All right.
Hold on, just relax.
People would have their witnesses available tonight.
The ninth?
Preliminary examination in this matter will be set in person September 9th.
Judge, I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Can we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
To the 8th, 30th.
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're going to go test. You're going to take that.
What I'm going to do is I'm going to order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post it in the fashion those are posted. You need to go over and take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed and sober link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays?
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether. Anything else?
No, Your Honor. Was she supposed to report back today after the testing?
No, she doesn't need to report back today. She needs to go over, take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Okay, thank you, Your Honor.
Court calls case People versus Khalil Haddon.
Joseph Engelman, people, Your Honor.
And Assistant Public Defender Lamis Saab on behalf of Mr. Haddon, who is approaching. Mr. Haddon, if you can say your name for the record.
Kahil Jabron Haddon.
Okay, go ahead.
Your Honor, discovery is complete in this matter, and we would be requesting to set it for preliminary exam.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
That's in person. Thank you. Bond will continue. Court calls case People versus Dwight Williams.
Andrew Childers appearing on behalf.
I'm here.
You know what? What's gonna happen though is I'm gonna call your case and you'll be nowhere to be found. Yes. The third 30.
Is this the way? Judge, can we pass the Mr. Williams matter? He had called me saying he was having trouble getting a ride from Detroit, but he promised me he'd try and be here.
Oh, he's not on a bus.
You being a considerate judge you are, I know you'll take that into consideration.
So this is just a delayed bench warrant.
Basically,
Yeah,
yes.
okay.
Thank you.
Pass. Court calls the case People versus Curtis is it Moncanito? Moncanico?
People, Your Honor.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. McConicle. Sir, could you say your full name for the record?
Curtis Mydro Mechanical.
Thank you. And Your Honor, we are requesting just a very brief adjournment. We haven't yet received discovery on this file. Our support staff reached out yesterday to the prosecutor's office, and I believe we should be getting that very soon.
August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls case People versus Derek Lovely.
Joseph and Yellow People.
Great Bird on behalf of Derek Love.
I was wondering where you were. It was not going to be a complete day unless you showed up.
I was thinking the same thing about you, you know.
Your name, sir?
Derek Lovely.
Thank you. All right, you're asking for an adjournment.
Please.
4th or the 11th, sir?
The 4th, please.
4th. Probable cause conference will be set September 4th, 2025, 9 a.m. Bond will continue in this case.
You and your honorable court have a great day.
Thank you. Court does call the case of People versus Michael McLean.
Alexander on behalf of the people, Your Honor.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. McClan, who's approaching. Could you state your name for the court?
Michael McCartney.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available to second.
We'll do our best, Your Honor.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her and not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Ender, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property. When she would come outside, he jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction. from 2007 and 2022 dismissed from eviction jurors, a 25 dismissed PhD, second, and malicious destruction of a building. And he currently does have a hold on standard for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it did.
HPA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly if it's arrested. If I can clarify, he went to the residence on 528, was served the PPO that day, and then in the preceding days after he was served the PPO and told he should not be having contact, he went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court is this is not a hearing date, so I know we can't get into the details. The missed call log and discovery shows 528 and not after. So we dispute that he made any contact with her after being served the PTO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case People versus Ahmed Ajabori.
Good morning, Your Honor. You and your staff, Brian Berry, appearing on behalf of Ahmed Al-Jabori.
Thank you.
Sir.
Ahmed Mohammed Al-Jabori.
Thank you.
Judge, today's the date and time scheduled for a PCC. We'd respectfully ask the court to adjourn to September the 9th if possible. The only reason is I have court almost every day.
September 9th?
Yes, Your Honor.
No.
Okay.
I need a green sheet.
I have a green
So
sheet.
you have, I could give you the 4th or the 11th.
Let's see.
Don't usually let people pick their dates, and then you did it anyway, and you picked the wrong date.
I did pick the wrong date. Do you have an afternoon docket on the 4th, Judge? I have a sentencing in Wayne County Circuit Court on a murder case on the 4th. And the 11th, I have a hearing as well. I'm sorry. I can.
No. Because so first of all, you being private counsel, chances are you're going to be in the afternoon anyway. I said everything at 9 o'clock, but I'm here all day. So I give you any of those dates, you will be set in the afternoon. Ms. Widely, can you make sure counsel is set in the afternoon? Otherwise, we'll never get done with this case. All right.
Thank you, Your Honor.
I don't know. He was doing whatever he was. Which date do you want, sir?
September the 4th is fine in the afternoon.
All right.
Thank
Probable cause conference will be September 4th, 2025. I'll set it at 9 a.m., but you'll be in that block. All
Thank you, Your Honor.
Notification. Thank you. Bond
Thank you.
continue. Your Honor. Thank you. Court calls case People versus Vandalis Patterson.
Ellie's on behalf of the people.
Good morning, Your Honor. Kerma Dadish on behalf of Mr. Patterson.
Good morning.
Good morning.
I've seen you walking around. You haven't said anything all morning.
Well, you'll hear me 4 more times, hopefully.
Oh, that's a threat. Go ahead.
State your name for the record, please.
Glad to Thank you.
Your Honor, I have submitted a green sheet. We are going to adjourn for mitigation purposes, and whenever there's a chance to address bond, please.
All right. Probably, well, the 4th gave you enough time to get something.
I would, if you could, the 11th, that's probably better. More time for our mitigation department.
So all she had to do was say no. September 11th.
Thank you, Your Honor.
2025, 9 a.m. But as to bond.
Your Honor, Mr. Patterson is charged with an Arno from 2022. He did fail to appear his last court date.
Well,
and-
3 of them.
Yes.
Yeah, go ahead.
But since 2022, he has had no other cases. He hasn't picked up any new charges. He's been working. He has 10 kids now, 7 of whom.
Excuse me?
Sorry?
What do you say?
I said he has 10 kids now, 7 of whom are in his care. What? You want me to continue or stop?
No, I'm stuck on 10, but go ahead.
Okay. He takes care of 7 of them financially. He's gotten himself a job. He works in landscaping and home improvement. He's been at his job for a year. He sincerely apologizes for not appearing 2022. He's told me that it was a dumb mistake that he didn't. He was immature at the time. He was trying to run away from his problems, but since then he wants to get his life back on track. He's already done so by not picking up new charges and by having a stable job. And he wanted to say something himself as well.
Yeah, I just want to say I was being sure I was running from my problems. I was, didn't want to go to jail at the time, but now I'm ready to face my problems and get on with get my warrants out the way so I can raise my family and have a clean slate.
How did he come into custody?
Traffic stop?
At the
police
room, police contact.
What happened?
At the room at Days Inn with my friend. She had the room for her foster care son. He had did something. So they had both rooms and they came and knocked them.
Hold on a second. So you came into custody not because you walked in from 2022.
He did not.
And he's at the Days Inn.
No, it was just passing because her son was in foster care, but she had the room. They were playing.
You at the Days Inn when you got picked up?
Yeah, well, they came to the room. Yeah,
they came to the room.
To the room for her son doing something, and that's
police contact that is unrelated to him.
Unrelated to me. Yeah, I didn't catch no charge.
And we did talk about him. He should have turned himself in since then.
Yeah, you were. Yeah, it was being skipped, but okay.
But, if your honor releases him on his own personal recognizance, it will come every single time.
2028, if his pattern holds.
There will be no pattern.
Well, that's all. So.
Okay. Ms. Zenda would like to speak. Ms. Zenda.
I would object to any modification bond. As the court has pointed out, he did fail to appear in 2022. He also has other holds are set for a 1482 case for an OWI that's up on September 12th. That's a $100 bond. Then a DV out of 14B that's up on September 15th with a $100 bond. In this case, there are 3 RNOs, and when officers went to arrest the defendant on the warrants that he had at the time, he was pulling away, not listening, was taken to the ground, had to be tased, and still continued to pull away. And then he also, when they had to get him to the car, he went dead weight and had to be carried. So I'd be objecting to any modification of bond, as well as with his criminal history. He's got 2 cleans that he was convicted of, a DVSC that he convicted on, a DV second, a unlawful driving away, and an OWI. So given the fact that he failed to appear for 3 years and had to get picked up, and then the facts of this case, I would object to any modification of bond at this time.
Can I briefly respond, Your Honor?
Give it your best shot.
All of these charges and his past history is from 3 years ago. The 2 cases that he has are $100 cash bond that convert to PR once he's released on this case. So he did PR on those. But all these allegations are from 2022. His criminal history is past that. Again, nothing since 2022. Those other cases, I believe those are also from 2022. So they're not new.
The only reason they're from 2022 is because he didn't turn himself in for failing to appear.
I did say nothing new from 2022, after 2022 since then.
Well, there's new things. He just hasn't appeared on those either.
Well,
2 other courts.
They're from 2022. He hasn't appeared on them, but no new charges.
Because he doesn't seem to want to go to court. I do have some concern that he's at the Days Inn, gets picked up at the Days Inn.
No, it wasn't that. But you guys just hear me out. Can you hear me?
Okay, sure.
I was saying up at the room with my friend. She got a foster son that they was paying for the room. They did something, whatever. That's how I ended up getting picked up. So I didn't turn myself in. Yeah, I understand that.
Yeah, that's the point.
Yeah.
One more chance, Your Honor.
Okay, I'll show up for home for 5 minutes.
Motion for bond reduction is denied. Bond will continue as is.
Thank you, Your Honor.
Thank you.
Court calls case People versus DaVon Julia Martinez. In Zoom. Oh, yep.
We're ready in this matter. On Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. DaVon Julia Martinez. Ms. Martinez, could you state your name for the record?
DaVon Julia.
Your Honor, today is a date and time scheduled for a competency review. We have received a report dated July 16th, 2025. Would submit that for the record. Has the court received that report?
I have the one dated July 16th. If that's the one that you're talking about.
Thank you, Your Honor. This matter was scheduled last minute. We do not have well, first of all, we don't have any further evidence to present to the court.
Any other evidence from the people?
I reviewed my internal file and I have not seen that competency report. I just Mr. Brown's handing a copy.
It's a determination that she's competent to stand trial. I believe you may not have it in your file because I think Judge Hamoud may have ordered competency. Right. That's 100%, but we received a copy.
Okay. Thank God the people have no further evidence.
All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent.
Thank you very much, Your Honor. We will prepare an order to that effect.
All right. And what would you like me to set the next proceeding for?
May we please have a probable cause conference date?
I'll set a probable cause conference for my next available date of August 28th, 2025, 9 a.m.
Thank you very much, Your Honor.
Bond is
Excuse me.
continued.
Sir, what is your name? The lawyer? Sorry, you? What's your name?
Lawyer?
Yeah,
I am Attorney Brown.
Brown, Mr. Brown. May I call you at the public
Yes.
defender's office?
You certainly.
Sure, he's there all the
Please
time.
feel free.
Awesome, thank you.
All
Good day.
right.
Alrighty. Ask for Lauren Brown.
That's Ronald Brown. Brown, no.
Thank you. Yeah.
Why would he do that?
Judge,
What?
this is him. This has been my whole state court. Doesn't mind.
It's
not the worst though.
Speaker.
You're glad. You're lucky my staff likes you. Court calls the case People versus Colin Spry. I'll call it up with your other one, Mr. Killer.
Assistant Public Defender Lamisa Saab on behalf of Mr. Spry. Mr. Spry, can you please state your name for the record?
Colin Spry.
Thank you, sir.
Oh, I'm sorry. That's good.
Okay, you're requesting an adjournment. At my next date, he's in custody. My next date would be the 28th. Would that be enough time to get the mitigation and try to?
Yes, Your Honor.
One more week out.
That'll be perfectly.
28th will work. Okay.
Yes.
Probable cause conference will be August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Christopher Atkins. From Livingston. Oh, there, okay. Christopher Atkins?
Yes, Your Honor.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins.
You have a camera there, sir, or no?
Yes.
Oh, there he is. Okay, we got you. State your name.
Christopher Roy Atkins.
Thank you.
Your Honor, we're asking for an adjournment. I know Mr. Atkins has been in contact with Mr. Bowling from our office. We are tracking his case in Livingston. He may be sentenced into a treatment court that would kind of help resolve the case here. So my understanding, Mr. Atkins, I looked yesterday, it looks like that was adjourned to the 22nd of August. Is that correct?
Yes, I don't qualify for the mental health treatment court. I think they were trying to get drug court, which is similar, but yes, 22nd is my next court date here. I also have calls here, September. So I have the 22nd, 12th of September. I'm not sure. I haven't talked to my lawyer what we're doing. So I qualify for mental health that I was.
Okay. Mr. Atkins, could you, we're going to adjourn today. Can you give our office a call and so that we can talk about what the status of your other case is?
Yes.
Did he say that other one was adjourned to September 22nd? Or
I
August
believe he
22nd?
has I don't want to say a new, but there it looks like there was a case that was bound over, and that's in September. I did not get the date on that. What's your September court date?
I have the September court date is 12.
September 12th. So if we could have a
12th.
date after
The 12th.
the 12th.
Sure. All right. Probable cause conference then, in this case, we'll probably hit right in the middle of those, will be September 18th,
Okay.
2025, 9 a.m. Bond will continue.
Thank you.
All right. Thank you, Mr. Atkins. Call your attorney's office, please.
Thank you, Your Honor.
All right. Court calls the case, People versus Jonathan Faith.
Joseph and Gilman, people.
Good morning, Judge. Lawrence H. Margolis with and on behalf of Mr. Faith, who is to my right. Mr. Faith, please introduce yourself to the court.
Morning, Jonathan Faith.
We've executed a waiver in this matter, Judge.
Why do I? What?
Say it again, sir.
This is
his agreement. We should wait that he filed today. I understand.
That's a term. Oh, he's only, I got you.
Yeah.
I got you. All right. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do.
People also waive the right.
We do, Your Honor. Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 and 4 following.
Judge,
Your turn, Margolis.
Thank you, Judge. We're in receipt of the felony information. We'd ask Your Honor to enter a plea of not guilty and waive.
Defendant having waived formal reading, pleading not guilty as to all 4 counts. Court will enter that plea. Pretrial will be set for
October 15th at 1:30 with Judge Conlon.
October 15th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Bond will continue. Thank you.
Have a good day.
You do the same. Court does call the case, People versus Jamie Foxx.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Ellis Friedman on behalf of Jamie Foxx.
Morning, Judge. For Assistant Public Defender, also on behalf of Ms. Fox.
Good morning.
Good morning. Your name?
Jamie Foxx.
Thank you.
Thank you, Judge. I haven't had the chance to speak to my client and to her other counsel. On my file, we are requesting this matter be set for preliminary examination.
That's, which one is yours? Is
We believe we have the discovery, Your Honor.
0223.
You want to exam also?
We've been trying to keep the case together.
I think we're ready now.
Okay. All discovery is complete then.
That's our understanding.
People have their witnesses available to second.
Your Honor, I don't think I'll be able to have the private guest up by the second.
Okay. Ninth?
Ninth is good.
Ninth is good. Will that work for you, Mr. Christian? And hearing no objection from the people. Bless you, whoever that was. Preliminary examination will be set in person September 9th, 2025, 9 a.m. before Judge Valvo in both matters. Bond in these cases will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. I don't know why. Who knows? Court calls the case People versus Delco Thomas.
Alexander, on behalf of people, Your Honor.
Well.
Mr. Thomas?
Yes.
And you want the adjournment?
Yeah, just. Okay.
Thank you, Your Honor. Stephanie Cannon, on behalf of Mr. Thomas. Mr. Thomas, could you please state your name for the record?
Delco Thomas.
And
Thank you,
we
sir.
are so happy to be here today, Your Honor, and
Yeah.
we're going to ask for a 2-week adjournment of this matter to see if some discovery can be obtained.
All right, I have a little longer than 2 weeks, or I have 10 days.
Your Honor, if we could do a little longer than 2 weeks, I was informed there might be exculpatory evidence on the defendant's phone, and that maybe officers are taking pictures of it, so that might take to see if they did or what that is. Your Honor.
Okay. Then.
Your Honor, I do
given
believe
that I can do the 4th or the 11th, which if we have it by then. But,
4th. Your Honor, we would ask for the 4th.
We can try something.
all right.
They took it to July.
Probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond will.
Somebody.
Let me see if I can find it.
Thank you. Court does call the case People versus Heather Booth.
Joseph and on behalf of people, Your Honor.
Bangladesh on behalf of Ms. Booth.
It's rushing. She's on the other one.
Sorry, Judge, I was on the record in another matter. I apologize.
Not a problem. I called the Booth matter.
Sydney Rushing appearing on behalf of Ms. Booth.
Your Honor, Miss Booth was going to show up in person. She is actually on her way to Richmond, Michigan to get herself into Sacred Heart. When she was released last, she was supposed to get released into treatment immediately. There were no beds for her, but now there are. I would ask that Your Honor adjourn this case.
You come up with the most incredible stories. Some of them being true, some of them.
Well, actually, I was
Don't tell me
texting with
you're
her
not
right
going
now.
to just show me a picture of anybody on a bus.
No buses.
Going anywhere.
No buses. I was asking her to send me proof of her getting into Sacred Heart. She just sent me something. She only sent me her tether thing right now.
Her what?
No, a proof of tether. She didn't send me proof of her getting into Sacred Heart yet. She said it was a telephone call with CMH and is working.
So she's admitted into Sacred Heart. She's on her way there, you think?
Mhm. Yes, I think.
Your Honor, that was my understanding as well.
Now you have two people telling you that.
What'd you say?
Now you have two people telling you that. So is it more
I have two
believable?
people that talk to
Rushing
the
is-
same person telling me that. I don't know that really bumps that up. Okay, here's what I'll do. I will issue bench warrants for the defendant's failure to appear in these matters. I, however, will not. I will not enter those bench warrants until the 19th day, till the 23rd. Well, 22nd is
Okay.
Friday.
Okay.
So if you get that information to us, I won't issue.
Thank you so much, Your Honor.
All right. All right. Thank you. What? 10,000 cash surety. Court calls the case People versus Olin Thurman.
People, Your Honor.
And Alex Warren Green on behalf of Mr. Thurman. Your name, Mr. Thurman?
Olin Thurman.
Your Honor, we are asking to set this matter for preliminary examination.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. And court calls the case of the people versus Christopher Taylor.
Joseph McGowan, people.
On behalf of Mr. Taylor, who's approaching and stands to my right. Mr. Taylor, please introduce yourself to the court.
Christopher Taylor.
Thank you.
Thank you, Your Honor. Your Honor, I was fairly recently appointed on this case. We are still working on discovery on this matter, so we're asking for a brief adjournment.
Without objection, September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Here, take this. I'll meet you in the hall.
Court calls the case people versus Cody Wines.
Joseph McGowan, people.
Assistant Public Defender Sandra White on behalf of Cody Wines. Mr. Wines, can you state your name for the record?
Cody Michael Wines.
Your Honor, I'm asking for an adjournment of this matter. I believe this is the first hearing for further negotiations and to review video with Mr. Wines.
Probable cause conference, August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Court calls case people versus Ma Sharif.
Joseph McGowan, people, Your Honor.
Morning, Your Honor. Mustafa Houili on behalf of Mr. Sharif, who's to my left. Sir, please state your name for the record.
Ma Sharif.
All right.
Your Honor, today's a day for PCC. There are two cases in this matter. There is a felony larceny and a unlawful driving away of a motor vehicle. Your Honor, he was arraigned last week. At this point in time, we've only received paper discovery on the larceny. We haven't received any discovery at all on the unlawful driving away. So I'll leave it to the discretion of the court judge if they want to, if you'd like to do an adjourned PCC for us to get up to date with discovery, or if you want to set it out for exam a few weeks out to give us enough time to review discovery and determine what we want to do with the exam.
I don't set exam until discovery is complete. You're telling me discovery is not complete. How much time do you need to get it done?
Judge, we just need the discovery on both matters. They're still outstanding, maybe a couple weeks.
That objection, probable cause conferences will be adjourned September 4th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Have a good day.
Thank you. Court calls case people versus Douglas Ren.
Joseph McGowan, people, Your Honor.
I'm Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Ren, who's approaching. Mr. Ren, could you state your name for the court?
Douglas Ren.
Your Honor, I have been in communication with the people on this matter. There's no offer available, and so I do believe discovery is complete. We would ask that this be set for exam.
People have their witnesses available September 2nd. Preliminary examination in person September 2nd, 2025, 9 a.m. That is before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Court calls case for the people versus Mary Collins. Collins, I think is.
On behalf of Mary Collins, who's approaching the podium. Ms. Collins, can you get up here, please state your name for the record?
My name's Mary Collins.
Thank you.
And one just says the date and time set for probable cause conference. We are working on mitigation, so we ask for a brief adjournment at this time.
Not objection, probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Nia Lee.
Alexander, on behalf of the people, Your Honor.
And Lord Yaki, Assistant Public Defender, on behalf of Ms. Brand. Ms. Brand, can you state your name for the court?
Zaria Brand.
All right, I have before me a plea sheet that indicates that defendant would be pleading to count 3, domestic violence, a 93-day offense. Upon a successful plea, counts 1, 2, and 4 would be dismissed. Defendant is agreeing to pay full restitution, and there's a sentence agreement or recommendation to sentence under 7694A. That's the court's full understanding of it.
And that's correct.
Yes, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Zaria Brand.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Seriously? Of course, hold on a moment. Here we go. On the date of May 19th, 2025, at the location of 755 Campbell Avenue, apartment 12, Ypsilanti Township, Washtenaw County, State of Michigan, what do you do on that day involving a Marquise Maddox that makes you think that you're guilty?
I threw a nail gun.
You threw a what?
A nail gun.
You threw a nail gun?
Yes.
At him?
In the direction of him, yes.
We're okay.
It never made contact.
Okay, good. But you were intending to place him in some apprehension of that contact happened?
Yes.
Yes. All right. And who is this individual to you?
My son's father.
Ma'am, I would have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, any sentence evaluation, in this case, the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 22nd at 10 a.m. Judge Washington.
September 22nd, 2025, 10 a.m. That is before Judge Washington. Bond with its conditions will come.
Your Honor, I apologize. May I address a bond condition?
She's out.
I understand. She does have a tracking
That to be
tether.
changed?
No, Your Honor.
Okay. Go ahead.
She does have a tracking tether. I believe she's had one since May. Is that right? Since she was arraigned on May 20th, which is the date after the incident in this case.
After she threw the nail gun?
Correct, Your Honor.
Okay, go ahead.
There's, to my knowledge, been no bond violations. Ms. Brand works, she's a working mother and she's in school. So she's starting her semester in just a few weeks at WCCC, studying psychology. And so she has a very, she's very goal driven and focused and wants to become.
Is she at Wayne County or Washtenaw?
Washtenaw, did I?
Yeah, you include one too many C's for Washtenaw. You've done that like 3 times already. It's okay.
Thank you for correcting me. I apologize. Okay.
You're welcome.
WCC.
Yes.
Okay. And she, so she would ask, given her lack of bond violations and her close supervision, now that she's pled guilty, she understands that any misstep, any violation will not only compromise her liberty in terms of going to jail, but it will also compromise her record and her future career in terms of losing 4A. So I would ask if the court would consider removing the tether.
Response.
Your Honor, at this point, I would object. I think it's something that could be addressed in sentencing. Given the facts of this case, I would ask that the tether remain at least until sentencing.
Sorry. What I'm gonna do is, I'm gonna let Judge Washington's probation department make a determination after they at least interviewed her before that tether is. So at this point, I'm gonna deny your request for a bond.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Dominique Brewer.
Chairman Dadush with and on behalf of Mr. Brewer. Please state your name for the record.
Dominique Brewer. Thank you.
Your Honor, we're just asking for a short adjournment, please. About 3 weeks, if Your Honor is willing to do so.
Probable cause conference, September 4th, 2025, 9 a.m. bond.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls case People versus Andre Brooks.
And Alexander on behalf of people.
Assistant Public Defender Chelsea Virgil, and on behalf of Andre Brooks, please state your name.
Andre Brooks.
We'd like to set a preliminary exam.
Discovery is complete.
I believe so, Your Honor.
You will have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Eric Buckner.
Ready in there.
Joseph and Nolan.
On Brown, Deputy Chief Public Defender appearing with and on behalf of Buckner who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Buckner, at this time, we're respectfully requesting an adjournment of a little over 2 weeks. Mr. Buckner has medical appointments. He also would like to be able to decide.
Sorry. He has medical appointments.
Yes. Have.
Will the 4th work?
Yes, 4th, please. Do you need to see these?
Probable cause. What is it?
They're just proof of his medical. He's got 3.
That's
okay. All right, thank you. Another word.
Probable cause conference, September 4th, 2025, 9 a.m. Bond will continue.
Your Honor, may we address just one aspect of the bond? He is out, but he's on home confinement. He has a lot of these medical appointments. They're going to vary. They're going to change. Just asking that the bond be changed to maybe a GPS so that he can go to work as well. He does need to be able to work to be able to pay his rent. He's got bills that are coming up. The home confinement prevents him from doing that. But mostly it's the medical appointments. He has 3 verified appointments that are coming up very soon. He's going to have more after that. So we're not asking that he just not have any kind of supervision, just a different kind.
I would indicate, I guess, I don't need a response necessarily from the people given that request, but what I would do is I'm going to leave the home confinement in place, making an exception for a verified medical appointment. So we would just need to turn that into any corrections.
Okay, can he also do employment too? Because the home confinement prevents him from even working. He's got to be.
A response regarding the employment. Is that, I mean, for employment to work, to actually work, or
Yes.
to interviews?
No,
I actually have a job, Your Honor.
he does have a job.
I have a job.
Your Honor, provided the definitive submit a verification that employment.
Okay, so he's got something here.
All right, so what I would do, Mr. Brown, if you prepare an order, get it over to the prosecutor's office, it had to be today. For my signature allowing his attendance at the medical appointments as well as employment.
Okay.
I will sign off on that, and get over to community corrections.
Thank you very much, Your Honor.
Thank you. And September 4th, and bond will continue with the changes. Court calls the case People versus Maurice Virgin.
Andrew Children appearing on behalf of the people.
What's called?
Virgin.
Virgin. Our prep row. Scooby.
I apologize, Your Honor. Lori Yackey, Assistant Public Defender with and on behalf of Mr. Burgess. Could you state your name for the court?
I'm Maurice Burgess, Your Honor.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Burgess about, and
Is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday, and we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday.
As well as CMH.
As well as CMH. And he came in with a written plan in his notebook. And I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he going to test clean?
Yes, sir. But I went in 2 days. Your Honor,
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society. I have a job. I start tomorrow at Full House Restaurant on Equals. I went to CMH and did my intake. I also went to Home Division and spoke with Mr. Marcus, who is a recovery coach on E-Course. All these places are within a half a mile from each other, from the hotel living in now. So I'm in position to lose my room, my residence, as well as my relationship with my fiance, who's clean and clinging on by her fingernail, because I'm trying my best to do my best and change my lifestyle, sir.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution. The bottom line is Mr. Burgess knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Divisions this morning and verified Mr. Marcus. I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance, who is with him, that he did that, and that he is clearly not using. He came to court to knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing, and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole, and he has this new new plan.
recovery coach, a new plan. a new
Oh, and he's going to
residence.
Little House meetings,
Yes.
multiple times per week.
I start
Um,
work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I've made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine. It almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana or THC at least in his system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started
And somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can. And I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance. And before I even talked with him, he came up with this plan himself. And I think that goes to show that he is taking the initiative to do this himself. And he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways, because he wanted to prove to the court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to, because I'm serious and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I don't. I can't do anything from jail. I have a job now, and I want to prove to myself as well as the court.
Anyone can do from jail.
Sir?
Nothing.
I'm sorry.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked. If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked, defendant's remanded.